Now, let me know once we are live.
We're live on both.
Oh, okay. Good afternoon, ladies and gentlemen. Thank you for joining us. Today is another day. Remember to invite your family, friends, colleagues at work to join us. Today is one of those days that I will be spending exactly 1 hour because I have a bond application at 1. So we'll be stopping early today. But I will spend the entire 1 hour. It's a WebEx hearing, so I'm going to be doing it on the computer. So I'll finish the entire hour. But without wasting time, if you have questions, start sending in your questions so that you stand the chance of getting your questions answered today, so that at least we get to you before we stop. In the meantime, as usual, not a whole lot of updates happened in the last 1 week because of the government shutdown, I want to assume. But of course, that doesn't mean we don't have any update at all. The first thing I want to talk about is that on Monday, USCIS announced that they are going to implement the court order regarding the asylum fee, that they have started complying with it. So they posted it that they have started complying with it. So they are no longer collecting the asylum fee. So as we stated before, if you have a pending asylum, even if you receive a notice to pay, please do not pay for now. A court has ordered that the payment should not be collected. Another thing I want to talk about is that AILA, American Immigration Lawyers Association, they reported to us that USCIS has updated that they have updated a centralized address for parole in place for military officers, military parole in place. So if you have a child who is in the military and you enter the United States uninspected, you can get your military son or daughter to apply for parole in place for you, so as to be enabled to so as to enable you to apply for adjustment of status without leaving the United States. It's only available for military officers. And the last one I want to talk about before we go into the questions. This is very frightening, but it is something that I have not verified. It was in the news. But the reason I'm talking about it is because I got to know about it through American Immigration Lawyers Association. And that is a very credible source when it comes to immigration update. That is a very, very credible source. It's not one of those hearsays. It's not a street talk. So that's why I'm going to talk about it. So American Immigration Lawyers Association informed us that, again, they are quoting CBS News, but they reported that the Trump administration has issued a guidance allowing U.S. visa officers to deny applicants for permanent residence based on certain medical conditions. I said this is frightening because if this is true, it's going to be really, really devastating. Now, according to this information, those medical conditions include diabetes, obesity, cardiovascular disease, mental health issues. That's what I would say. This cannot be, I mean, if they implement this, a lot of people are going to be denied. I mean, how many people are struggling with diabetes? How many people are struggling with obesity, cardiovascular disease, mental health?
And mental health, I even
I mean, that will even be illegal. Why would they deny somebody based on mental health, especially if the mental health maybe was created by a U.S. citizen spouse and it resulted in VAWA? So if you are going to deny adjustment of status based on mental health, again, like I said, the only reason I'm talking about it is because it was posted by American Immigration Lawyers Association, but they are also quoting CBS News. So I'm going to look for the policy if they ever posted it, but it has not been posted anywhere up to today. I was even checking it this morning before I came on here to see if immigration will publish anything regarding it, but they have not. But they better don't implement this. I can assure you, this will lead to a lawsuit, definitely. Because, I mean, even most immigration officers themselves have diabetes. Most immigration officers themselves are obese. So what is the issue about that? But of course, as we already know, Trump administration, they don't have any boundary. So they keep expanding the boundary, they keep expounding it. But I'm sure this one will end up in court. Well, anyway, don't let me waste a whole lot of time on it because, like I said, we have very limited time today. Let's see. Is this for me? Or are they from previous?
That's previous.
Oh, both of them? Okay. Okay. Okay, let's go straight into the questions because we have limited time. I have a bond application at 1 o'clock. Okay, first question, please. Okay, good day, doctor. Thanks for all you do. You're welcome. I'm a green card holder. My partner is on F1. I submitted I-130 on 11/5, November 5. Can we submit I-485 and EAD if date of filing becomes current, even if both of us are here in the US? Yes, but the condition is what you yourself you have mentioned. Number one, visa must be current. Number two, your wife must be maintaining legal status. So since you said your wife is on F1, yes, you can submit adjustment of status as soon as visa becomes available, but she must keep maintaining status until you are able to submit the I-485. But yes, you can do it even if you are here in the US. The only requirement is that visa must be current and your wife must be in legal status at the time of the application. Next question, please. God bless you and your team, sir. Amen. EB2 NIW priority date is January 12, 2024. Kindly explain what this means in the November visa bulletin. You must use the date for filing. Can you check the November bulletin? Okay. Okay, is that the second part of the... Okay. Kindly explain what this means in the November visa bulletin. You must use the date for filing chart in the Department of State visa bulletin for November 2025. I plan to file AOS soon. Is there any other question?
Dates for filing, that's the one for people who are outside of the country.
Oh, I mean, it's for,
Go back to the question. Let me see. Kindly explain what this means in the you must no, I thought you okay, you must use the date for filing chart in the Department of State visa bulletin. Well,
Let me see what you
date for filing chart visa application. That one is for people who are outside the United States. What is that second one?
dates.
oh, you mean on the visa bulletin?
Uh-huh.
It's
Let me see the visa bulletin. This is employment based since he's talking about EB2. This is November.
usually that's what it says on USCIS.
Yeah, I'm looking for what is quoting.
Yeah, let me look for it. I did.
But generally, the date for visa application, that is for people who are outside the United States. And the what is the other one called? That was what I wanted to check. I ended up checking something else.
It's the final action date.
Okay, yeah, the final action date are for people who are physically present in the United States, but the visa application date are for people who are outside of the United States, who are applying for immigrant visa from out of the United States. But sometimes USCIS do allow people who are inside to use the date for people who are outside, because most of the time the dates are not usually the same. So that may be what happened here, but I want to confirm because I've not really checked the visa bulletin for November.
This is what they're talking about, I think.
Yeah, this does not change anything. That one is just saying that they should. This is just telling applicant to follow the Department of State visa bulletin chart. But again, for visa application, those are people applying from outside of the United States. And for final action, those are people who are inside the United States. So you just have to check your, what I wanted to check. Since it's talking about EB2, what is the priority date
So the one
for EB2?
USCIS says for adjustment is July 15th, 2024.
And it says, can you go back to the question? When is this?
January 12th, 2024.
And you said they are in July. Did you say they are in July?
For final action?
Then his visa is current. So why is he not applying for adjustment? Well, whoever sent this question, based on the information you provided, if your priority date is January, they are already in July. So the visa is current. Visa is current. So go to the next question, please. Good afternoon, sir. God bless you and your team. Grateful for the podcast that help in all ways. Thank you. Okay, there's no question. It's just, okay.
Okay, let me see.
Yeah, just check right quick before I go into other.
No, sir.
Okay. Hello, sir. It's been 1 year, 1 month since I filed my I-130 for my wife that stays abroad and no response yet from USCIS. And I'm a US citizen. What's the processing time for now? Is it normal? How long? 1 year and 1 month. Well, in order to answer the question, it depends on where your I-130 is pending. Since your wife is outside the United States, so this is a standalone I-130. So standalone I-130s are processed by service centers. So look at your receipt notice and look at the service center where your case is pending. If your case is pending, can you please check the current processing time for I-130 standalone? But if for any reason your case is pending at the National Benefit Center, you are out of luck. That one, their current processing time is over 4 years. So it depends on where your application is pending. So check the receipt notice, look at the receipt notice. It will give you the address where your petition is pending. So look at the service center. But if it is National Benefit Center, you are out of luck. All you can do is to wait, or you can use a congressional intervention.
So if it's just at a different service center, it is 17 months.
17 months, that's 1 year and 5 months. Okay. For other service center, it's 1 year and 5 months. But if it is National Benefit Center, like I said, it's over 4 years.
2 months.
What?
4 years and 2 months.
It's 4 years and 2 months for National Benefit Center. Next question, please. Also, sir, a friend filed an I-140 from Nigeria using my US address. E-payment made from my US account and DHL shows delivery to USCIS, but no receipt notice or email yet. What should we do? Can you file I-140 electronically? So this is actually a paper filing. Yeah, you have to wait. Once you have proof of delivery, just wait. I hope you have not done something wrong that will make them reject it, because if it is rejected, because USCIS does not mail anything with overnight or priority, they use regular mail. If it is rejected, sometimes it can take 2 months before you even realize that they are rejecting it. But if it is not rejected, you will still get the receipt notice. Sometimes receipt notice take time. Not always, but sometimes. We have seen a situation where receipt notice took about 3 months. But it's not usual, but it does happen once in a while. So it's too early to complain if you have not received anything. But if after 3 months you have not received anything yet, that's when you have to be concerned. Next question, please. Good day, sir. I came in August 24 with B1, B2. I'm assuming August 24 of this year. Okay. With B1,
No,
B.
no, I think it's the year 2024.
Yeah.
Oh, August 2024. Okay. With B1, filed L1 visa November 24, got I-797 May 25, approval pending. Can I file EB1C petition currently or wait till decision on L1, or what other route can I explore? Well, as to if you are eligible for what?
That's the follow-up. That's the second one.
Yeah, let me, I believe that's a different question. Yeah. I think that one was talking about filing EB1. Can you go back to it? I got distracted. Can I file EB1C? Yeah, that's one. Well, if you are eligible for EB1C, yes, you can file it because you still have a pending petition that has not been adjudicated. If you are eligible for EB1C, yes, you can file it. You can exploit if you are eligible. But as to talking about what other option, that is an open check. That's not the kind of question I can answer on this podcast, because that question alone will take the entire 1 hour, and I will not even finish it in 1 hour. That's an open-ended question. Go to the next one, please. Good afternoon, sir. I have approved NIWEB2 self-petition and change job in same field. In the AOS, I'm to provide statement of intent to stay in approved field. Is the statement enough, or I have to give other document proof? No, if the I-140 has already been approved, the statement is enough. Go to the next question. Good day, sir. 2 kids aged 16 and 10 just came into the country via their U.S. citizen stepmom, who petitioned for them. When are they eligible to file for citizenship? Father has 2-year green card. What is the age again? 2. Okay. Because
No, 16 and 10.
16 and 10. Okay. Yeah. Whenever the father becomes a citizen, if they remain, if they are still under 18 at the time that the father become a U.S. citizen, then they don't need to apply for citizenship because they will acquire citizenship automatically. On the other hand, if at the time that their father becomes a U.S. citizen, they are already 18, then they will have to apply for citizenship 5 years from the date of entry into the U.S., except if, of course, they join the military. But if their father becomes a U.S. citizen before they turn 18, they don't need to apply at all. The citizenship will be automatic. Okay, this one just says thank you. You're welcome. Okay, go ahead. Good afternoon, sir. The online payment form G1450 is only credit card indicated. Can I input debit card info also? Which payment method is better, card or ACH payment from? Thank you for all you do for us, sir. Okay. On the debit card thing, you are the one that can answer that. Is it possible?
Yes.
Okay, yeah. I understand you can use debit card as well. But which is better, ACH or card? There's really no difference. It's the same thing. It's the same thing. You can use either one. Debit card, credit card, it doesn't matter. But I think a debit or credit card will be easier because ACH, that one will be authorizing the bank and sometimes instruction may go wrong. But with the debit or credit card, you just put the credit card information or debit card information, the number, the expiration date, and security code, and you'll be fine. So I think the card will be much better. But yes, you can use a debit card. Next question. Good day, sir. A marriage-based green card was approved 2 weeks ago. Until now, no card has been posted. Do you know what caused the delay and how long does it take to receive the card? Please. Okay. Okay. Well, if the applicant has received a letter, an approval letter confirming that the green card has been approved, there is no cause for worry. Sometimes the card itself may take up to 30 days, but that's not a problem. But if all you see is an email or online post stating that it has been approved, that is not evidence of permanent residence, then that one may require a follow-up. You may need to call USCIS, but even then, you still have to wait 30 days because it will not even allow you to do service request in less than 30 days. So you still have to wait. 2 weeks is not out of the ordinary. It's still within normal, within 2 weeks. Normally, 30 days from the date of approval. But if you have received an approval letter in your hand, forget it. Even if the green card does not come, you are still a permanent resident. But after 30 days, you can always do a service request. Next question. Please remind me, or maybe you want to set alarm. I have to be here by 1. Can one stay in Nigeria for 4 months with 36-month extension on a 10-year green card? I also have permit to re-enter the US, which expires in 2027. Yes, you can stay in 4 months. However, if this is family-based, if you got your green card through your spouse, you need to let your spouse be fully aware of your movement. That's it. But yeah, there's nothing wrong with staying for 4 months. Yes. Hello, sir. Is there a question from that?
Yes, sir.
Okay. Is it advisable to transfer with advance parole to your home country? What do you mean by transfer?
Maybe to stay over there?
I'm not sure I understand the question.
Maybe they want to continue with the process abroad.
I don't understand the question. But if the question is that you have a pending adjustment application and you want to process it abroad, can you do that? Yes, but the process is complicated. It's not, you can't do it with advance parole. You have to file IA-24, instruct USCIS to send the file to National Visa Center. You have to apply to National Visa Center for immigrant visa. It's a long process. You can't just transfer a pending adjustment application to the embassy. Remember, your pending adjustment application is with USCIS, and the embassy is not part of the USCIS. They are part of Department of State, whereas USCIS is part of the Department of Homeland Security, so they are not the same thing. So the process of continuing is completely different, if that is what the question is. But I don't understand what you mean advisable to transfer with advance parole. Okay, if you are online, you can clarify it, but if my answer have resolved the question, then let's move on. Okay, next question. Good day, sir. My sponsor's current tax return is short by 1K. Can he use his bank statement to support the tax transcript? No, bank statements are not acceptable, but assets are acceptable. if he has stocks, if he has investment, if he has a 401k, if he has a property, if asset can be used, but bank statement, no, because bank statement, you can have it today and tomorrow you can go and withdraw your money. So bank statements are not usually accepted, but asset can be accepted. If he has a property, even if he's still paying mortgage, the equity is considered an asset. If he has a 401k, those are considered assets. He can use his asset, but not bank statement. Next one.
Person sent.
The person, yeah. This is the person that talked about the travel.
Okay, sir, my case is 3 years. I mean, I-360. Can I still travel with my advance parole? I-360 is not something you can travel. Okay, the way I understand this question, maybe he has approved I-360 and has a pending I-485 adjustment application. So you want to know if he can travel with advanced parole. Yes, but where is the issue of transfer coming in? I still don't understand it. But
Maybe they meant travel instead of transfer?
I think it's travel, you're right.
Is it
Advisable to travel with advance parole.
oh, okay, travel, yes. Yes. Oh, yes. You can travel for as long as you don't have criminal record. Yes, you can travel. Yeah, the question say transfer. That's why I was confused. Yeah, if it is travel, yes, you can travel for as long as you don't have criminal record. If you have criminal record, you may be detained or upon your return. But without a criminal record, yes, you can travel. Next question. Can one apply for B1, B2 after forfeiting a 10-year green card? Oh, yes. Oh, yes, you can apply. Of course, especially if you forfeit it voluntarily. I mean, so that will demonstrate that you don't have immigrant intent. See, I was even a former green card holder, but I voluntarily turned it. So I prefer to just visit. I don't want to live there. I don't want to migrate. Yes, you can apply. Although you also need to understand that it remains a discretionary issue. It's not automatic that they are going to give you. It's still a discretionary issue. You will still be at the discretion of the officer, but yes, you can apply. Next question. Hello, doctor. Thanks for your sacrifice. You're welcome. Thank you. What are the precise documents to be submitted to USCIS for adjustment of status with respect to family-based petition? Well, you don't indicate who is the petitioner. If all you are asking for, if this is based on marriage, you have to submit your marriage certificate because that is what will show that you are married. You have to submit your birth certificate. Everyone applying for green card must prove identity. And one of the evidence of identity is your birth certificate. So you have to submit your birth certificate. You have to submit evidence of legal entry. If you are applying from the United States, you have to show that you entered the United States legally. So copy of your visa, copy of your I-94, copy of the biometric page of your passport. And of course, you have to submit passport photograph for yourself, passport photograph for your petitioner. And more importantly, if this is based on marriage, you have to submit evidence of your marriage, evidence of your relationship, evidence of commingling of assets. So those are the things that you need to submit if this is based on marriage. But if it is based on parent-child relationship, you need to submit everything that I've stated except the evidence of relationship, but you still have to submit something different. Parental child-parent relationship, you still have to submit evidence of child-parent relationship. Maybe school record when the petitioner was young. Maybe immunization record. Maybe pictures when you are a baby. All those things, you have to submit all that. Next question, please. Good day, sir. Please, what is the best way to respond to birth certificate RFE after submitting local government birth certificate with the original submission? I was born in Nigeria in 1985. Well, if you are from Nigeria, what you need is attestation of birth from National Population Commission. So go take the birth certificate that you have to the National Population Commission, and then the National Population Commission will issue you attestation of birth. That is what you need to submit. Next question. Greetings, sir. Please, is it possible to adopt a 14-year boy, and what are the best process of bringing him to the US? Well, there are so many questions that are not answered in this fact. There are so many assumptions. There are too many things that I don't know. Number one, adoption. Yes, you can adopt any child that is under 16. Under 16. So this is a 14-year-old. This person can be adopted. But as to the process, that's a complicated question. That's not a question I can answer here because, number one, I don't know if this person is an orphan. If the person is an orphan, the procedure is different. If this person is not an orphan, the procedure is different. Even the person applying, I don't know if this person is from a country that is part of the Hague Convention. There are so many things that I don't know. And if I want to start addressing it one by one, I'm probably going to spend about an hour explaining this. So the issue is adoption can happen before age 16. Next question. What is meant by your case is being actively reviewed? Our record shows nothing is outstanding. Yeah, it means that they are working on your case. They just don't want you to start calling. That's why they are giving you that information that they are reviewing your case right now. They don't need anything from you at this time. If they need, they will contact you that they are reviewing your case. So that's what it simply means. So it may also mean that once they finish, they will call you for interview. But if your case does not involve interview, but it simply means that they are working on your case. That's the simple meaning. Next question. Does child summer EBT benefit affect immigration application? I don't think so.
Permanent residents, maybe.
You mean for non-permanent residents, you mean? It cannot be for permanent
people that are
residents.
applying for permanent residents, you're the one to.
Yeah, but summer program, I don't think so. Do they give them money?
Yes, they give him a card.
They give them a card?
Yes.
Well, to be honest with you, this is a question that I'm not 100% sure. And usually I don't want to give an answer that I'm not 100% sure because I don't want to mislead people. I do know that a lot of people rely on the information we provide on this podcast. So I'm very, very conscious of that. And for that reason, I don't want to provide information that I'm not sure.
I can tell you what is safe benefits for permanent residents.
Okay, go ahead.
So the Affordable Care Act, marketplace insurance, the premium tax credits,
Okay.
Medicaid, depending on the state if they qualify, and Children's Health Insurance Program, CHIP. But other than that, I mean, it could affect them.
Okay, yeah. I've just been, my attention has been brought to this. The things, go over it one by one. These are I think you mentioned 4.
4.
These are the 4 items that
Safe
can
benefits.
affect your immigration benefit.
No.
Only 4. Anything
safe.
outside of these 4.
Safe benefits. Safe.
Yeah, it means that those are the ones that are safe for you.
Yes, to take.
Yeah, that's what I said.
Okay.
That's what I said. So, Affordable Care Act, that is Obamacare.
Well, not anymore Obamacare, but
Well, Affordable Care Act,
yes.
premium tax credit, Medicaid, depending on your state, and Children Health Insurance Program, CHIP. So those are the 4 things that you can safely do that will not affect your application for permanent residence. Next question, please.
Application? So if they are permanent residents, those are safe?
No. Those are the things that will not affect your application for
That's what I
permanent
wanted.
residence. Yeah, that's what I said. Next question, please. So, Good afternoon, sir. Please, how can I book a consultation session with you? Okay, somebody will.
It's on the pinned comment
Okay,
on the
yeah,
top.
just respond to this person. Go to the next question, please. I want to try as much as to answer as many questions as possible because we have very limited time. God bless you and your team, sir. Amen. A man said it on social media that one cannot travel with parole again, that when you are coming back, you will not be allowed to enter the country. Is it true? This is absolutely untrue. It is not true. It is only if you have criminal record. That is when you will not be allowed back in if you have criminal record. It is not true. We have clients who travel from time to time with advanced parole, even as recently as this November. So that's not true. Go ahead. Is the next question, is the 128 civic questions written or oral? God bless you and your team, sir. Oh, they are oral. Actually, the way they ask during interview, the officer is going to sit in front of you. As I'm sitting down now, you will sit on the other side of the table, and the officer will ask you. They are not going to ask the entire 128 question. You need to know the entire 128 question. They will only ask you 12 questions. But because you cannot predict which 12 they will ask, that is why you need to know the entire 128. But they are just going to ask you verbally, orally. It's not going to be in writing. They are going to ask you orally. So when you answer it correctly, then there is a written part of the citizenship interview. They will give you a pen and paper or ask you to use your finger to write on an iPad. They will dictate something and they will tell you to write it down, usually one sentence. For example, they can dictate who lives in the White House. They will ask you to write it. Who lives in the White House? Or they can ask you questions like, which state has the most people? They ask you to read it. Then you read it. They give you the answer and they ask you to write it down. So if the question, for example, is which state has the most people, they will ask you to read it. Then they will ask you to write the answer. They will give you the answer. California has the most people. So they will ask you either to use your finger to write it on the iPad or they give you a pen and paper to write it on a pen. California has the most people. If the question is who lives in the White House, then they will give you the answer. Write it down. The president lives in the White House. That's the way the interview is. So as for the 128 question, no, they are not going to ask you to write anything. They will just ask you orally 12 of the 128 questions. Next question, please. Before this,
Okay,
is
from
it
this
the same person?
It's from the same person. What is meant by your case is being actively reviewed?
Okay, go on to
So
the.
this is the next question.
Okay, before this, there was RFE about father-daughter proof of relationship before child turned 18. Child filed for both parents. Yes, I mean, if you have responded to the RFE and they tell you they are reviewing it, yes, it means that they have received your RFE and they are working on it. As I just stated recently when I was answering the previous question, if a child is petitioning for parent, yes, evidence of relationship is part of the requirement. You have to show evidence of relationship, maybe school record, immunization record, pictures of when the child was a baby, maybe 10th year birthday, first year birthday. I mean, everything that has, I mean, if you have other pictures, if there are specific events that the child feature or the parent feature, yeah, you need to provide all those things. Even baptismal record can also show evidence of relationship. Next question, please. Good day, sir. Please asking for a colleague. Our mom is a U.S. citizen. but she came in on a tourist visa 4 years ago and filed asylum after her 6 month stay expired. Can she adjust status if her mom?
There's nothing else.
Well, I think I know what they are asking for. They want to know if her mom's petition was approved. Can she adjust status? Well, it would depend on a number of factors. Number one, it would depend on whether she filed the asylum before the expiration of her I-94. If she entered the US on a tourist visa and they gave her I-94 that is valid for 6 months, for example, and if she applied for adjustment before the expiration of the 6 months, if the mother's petition is approved and visa is current, then she may be able to apply for adjustment of status. But remember, U.S. citizen petitioning for unmarried child right now, I think the waiting period is about 13 years. If I'm not, can you please quickly check? That should be EB1, U.S. citizen petitioning for unmarried child. Even though the question didn't indicate whether this person is married or not, but I do know that for married children, they are processing 2009 because I checked it this morning. That one I know. And I think they are processing 2013, either 2012 or 2013 for unmarried children. So I don't see how this person can adjust status now because visa is not even current. Yeah. F1 and F3. I know that F3 is 2009, January 2009, because I checked it this morning. They are processing petitions that were filed on January 1st, 2009. But for unmarried children, I know they are either in 2012 or 2013. July.
November.
No, it's somewhere July.
I'm saying according to the November visa bulletin, F1 is November 2016 and F3 is September 2011.
Oh, okay, you are right. I think I checked employment based before. Okay. Yeah, family based. F1 is when? That is unmarried child of a US citizen.
It's November of 2016.
November 2016. That's still how many years now? That's like 9 years. And the and the married.
So that's another 5 years because it's September of 2011.
Married children is September of 2011. Unmarried is 2016. So both of them are still pretty long. So it's unlikely that you'll be able to apply for adjustment of status. Okay, next question. Is it true, I mean, sir, that you will not allow to enter the country back with your parole? No, that is not true. People still come in with advanced parole. But if you enter the US unlawfully without a visa, yes, you may have some challenges at the port of entry. If you have criminal record, yes, you may have issues. And of course, if your application was denied while you are outside, yes, you may have it. So there are a lot of, every case is different. Can you travel? Yes. Does it come with some risk? Yes. But every case is different. Primarily, if you do not have criminal record, there is nothing to worry about. You can travel with your advanced parole. Next question. Good afternoon, sir. So the AAF has been phased off now. What is AAF? Phase off now. I don't know. If the writer is online, you can clarify it. I don't know what you mean by AAF.
Oh, annual asylum fee?
Oh,
Oh, okay. Yes, it's not phased out, but it has been suspended. There is no payment required now. Yes, no payment is required for annual asylum fee. I didn't even know that they've shortened it to AAF.
Oh, I didn't either. That's like
Yeah. Yeah, annual asylum fee has been suspended for now. No payment is required based on a court order. Good day, our seasoned attorney. May God continue to bless you richly and your team. Amen. Thank you. Since the $100 annual fee for asylum has been put on hold, will those who paid already be refunded? Well, it's too early to determine that, but I don't think they will be refunded right now because remember the case is not over. This is a temporary injunction. When the case is finally over, if the court rule that immigration does not have the right to collect those fees, which is what the ASAP is saying, that immigration does not have the right to charge those fees. Those fees can only be charged by the Congress. It is the Congress that has the authority to pass a law. Any law that is passed by Congress can only be implemented by the executive branch. So that is their basis. So if the case is finally decided and the court ruled that USCIS does not have that authority, at that stage, yes, everybody that paid will be refunded. But for now, because it is a temporary injunction, we can't guarantee that refund will be made, because what if at the end of the case the court conclude that USCIS can charge the money, then they will start again. So no refund will be made at this time. But at the end of the case, if ASAP win the case, yes, refund may be issued. Next question, please. Good day, sir. How long does Form I-212 take for approval? Can you check the processing time? Okay, go to the next question while we are checking that. I don't have the answer in my head. We have to check the processing time. God bless you for all you do. Amen. Currently on R1, what's the priority date for EB4? My priority date is April 2025. I know it's not even close, but we'll check. Can you please check the priority date?
So for the I-212,
Yeah.
it's 37.5 months.
37 months. I believe 36 months is 3 years.
Yes.
So 3 years and 1.5 months. Okay, for the I-1212, yes, the processing time posted is 3 years and 1.5 months. That's the processing time that was posted. What's the priority date for the EB4?
Does it say if
It's based on religious EB4.
I mean, the certain religious workers is you. The
Unavailable, that's usually with the final action. What about visa application?
It's also you.
For November. Well, you simply means unavailable right now. But another visa bulletin should be out even before the end of this week. One should be out by Friday. Yeah. So for now, for this November bulletin is unavailable. Next question. One of two. I didn't know I have a number through my expired OPT EAD until after I submitted my adjustment of status package without filling out the A number in the forms. Biometrics appointment came with another A number. Go ahead. Other notices have the A number on the expired EAD notice, and my account profile now shows the A number. Please, what's the implication of this? What should I do or be worried about? Well, you don't need to be worried about anything. If you are invited for interview, bring it up during the interview and USCIS will fix it. They will match the two alien number. So it's not a big deal. It's not something that you need to worry yourself about. It's a problem that can be solved. It's not a big deal.
10 minutes.
Okay. Next one. I've been reminded I have only 10 more minutes because I have a bond hearing at 1 o'clock. Okay. Hello, Dr. Asekun. Thank you for all your good works. Thank you. You're welcome. As a U.S. citizen, I petitioned for my kids 14, 12, and 10. Priority date is June 2023. And DQ documentary qualify is August 2024. It has been a long wait. Please, do you know when, move it up a bit, when they are likely to be called for interview? They are in Nigeria. Well, as a US citizen, you are not supposed to be affected by a priority date or any issue like that. US citizens are not affected by all those priority date problems. Your children, because they are 14, 12, and 10, all of them are members of your immediate family, so they are not affected by priority date. So your case has been pending for more than necessary. So I will advise you, because this is a case that is already out of USCIS, so you can't even do any service request at this time. So based on that, I would just advise you to do congressional intervention. Go and look for the congressman representing your district, and then go to the congressman, and they will ask you to fill some form because they need authorization because of privacy law. If you don't authorize them, USCIS will not talk to them. Department of State will not talk to them. So make sure you provide authorization to them and tell them that, look, you are a US citizen. You need your children here. This process has been ongoing for more than 2 years. And all you want now is just for them to be interviewed. I assure you it works. It works magic. But I didn't believe that I would have to say this on here, but that is the truth. If your congressman is not a Republican, it may not work under this administration. That is the unfortunate truth. So my advice to you, if your congressman is not a Republican, look for your state senator. If your state senator is a Republican, go for a Republican representative. But if neither of them is a Republican, then you can do the Democrat, you can visit the Democratic congressman and back it up with prayer. God will help you. But I know that Republican Congress people, they are very, very efficient at this time under this administration. Next question, please.
I have noticed that they've been trying to expedite all these people to be scheduled for an interview. They've been calling them like back to back.
That's the embassy. Oh, okay. Yeah, maybe
They're like really trying
to clear the backlog.
exactly.
Okay. Yeah, I've been told that they are really working on it right now to clear the backlog. So hopefully, but I will still try the congressional intervention. It doesn't cost you anything. It just, all it costs you is a trip or a phone call to the congressman's office. So go online, search the congressman representing your district. You can search by your zip code. It will give you the answer. Usually you will get their information online. You will see their phone number. Every congressman or senator have a local liaison office. Call them, tell them what you want. They will tell you. Sometimes many of them have this authorization form online. So you can download it, complete it, email it to them, or fax it to them, or take it there in person. That's all that it costs you. So it doesn't cost money. So I will do it if I'm in your shoes, because it works, like I said, especially if the congressman is a Republican under this administration. It does work. Next question. My mother petitioned for me and my family in 2012, Houston, Texas, and I-130 was approved, but visa is not yet ready for us until 2028. How do you know it's going to be 2028? That's a very, very serious guess. And I can tell you that's not an educated guess, because visa bulletin does not depend on the year. It sometimes it approbates, sometimes it retrogress. So it's not something that you can guess. But anyway, what's the question? Why so long? I came to USA alone in 2016 with B1, B2 and never go back. Oh, this person may not even be you may not even be able to adjust status when visa eventually become available. The reason it's so long to answer your question is because there's a numerical limit that there's a limit to the number of green card that can be approved for people who are considered extended family member. Because you are over 21, you are not considered immediate family. Only children who are under 21, those are the ones considered immediate family. So you are not an immediate family member. You are considered extended family member. That is why it takes so long. But again, it approbates and reprobates. Currently, you may be looking at 2028, but it may be earlier and it may also be further than that. So it's not something that you can determine ahead of time. Next question, please. What should I do if I'm being called for interview? I'm here and my family is in the UK. Oh, is it the same person? Oh, okay. No. How can it be called for interview when I-130 has already been approved? Go back to the previous one. I thought he said they already have an approved I-1. So you can't be called for interview. You cannot be called for interview in this case. Interview is only when you apply for adjustment of status. And like I said, adjustment of status is based on if you are maintaining status. But because you have been out of status, you may not even be eligible for adjustment of status. Secondly, it doesn't ask for your siblings who are outside. The fact that your parents petition for all of you does not mean that your case is being processed together. As far as immigration is concerned, everybody is treated individually. So your case is going to be processed individually. Your siblings are going to be processed individually. So all of them are going to be processed separately. No, you are not together. So if their own is processed through the embassy, they will be interviewed at the US embassy, either in Nigeria, or they can request to be interviewed in the UK if they have legal status in the UK at the time, whenever visa becomes current. Next question, please. Sir, please can I work for another employer outside a religious setting with an approved EAD under the R1 EB4 category while awaiting I-485 adjudication? My R1 expires January 2026. No, sir. No, you cannot. This is a very good question because we see the impact all the time. You cannot. R1 religious workers, the religious worker petition, I-360, they have something that every other visa category does not have. And that thing is the word solely. S-O-L-E-L-Y. Solely. So you can only work solely for the religious organization. You can only work solely in a religious capacity. You cannot work for another petitioner outside a religious setting. You cannot legally do that. If you do, even the 360 that has been approved will be revoked. I have seen this happen 1,001 times. You cannot. The word solely is very important. You are coming, every religious-based petition indicate that you are coming to solely work for the religious entity. So you are not permitted to work for another religious organization. Next question, please. Good afternoon, sir. Can I travel with I-94 stamp on my passport to Nigeria? I have 2-year green card in 2019 waiting for a response on 751 since 6 months. The passport is not enough. You can travel with your expired green card, the letter extending your green card, and then if you have a stamp, either the letter or the stamp, but you still need the expired green card. Both of them, you travel with combination of all of them.
But it's not called an I-94 stamp, it's an I-512 stamp.
Yeah, it's not an I-94 stamp, but the person may just misinterpret it. But I know if it is stamp, you can travel with that stamp. Okay, let me answer the last question before I go. Last one. Is that the last one? Okay. Good day, sir. Is it advisable to file I-601A despite being in USA? will it protect from deportation? I-601A is unlawful presence waiver. It is only meant for people who enter the United States without a visa and they have an approved immigrant visa and they want to go and apply for adjustment for visa at their home country. But because they have entered the US without inspection or because they have overstayed, if they step out of the country, they will be barred for either 3 years or 10 years. So in order to prevent that 10-year bar, that is what I-601A is meant for. So it is only meant for people who are here unlawfully and plan to go back to their home country to apply for immigrant visa. So for you to file I-601A, you need to have an approved immigrant visa before you can file I-601A. So it's not going to protect you from deportation. Well, on this note, I have to end it today because, as I said, I have a bond hearing. I have someone who is detained and I'm trying to get the person out on bond. So I have a bond hearing. I will have to leave at this time. I want to remind you, stay out of trouble. Remember to join us again next week, Wednesday, 12 p.m. Central Standard Time or 1 p.m. Eastern Time or currently 7 p.m. Nigerian Time, 10 a.m. Pacific, and 11 a.m. Mountain Time. Until next week, remember to join us.
Maybe
What?
you want to just address this last comment.
They say that we skipped
That is
them.
not fair because you skipped their question, but you just
Again.
didn't get to it.
Yeah.
So
Oh, I
maybe
skip it.
you
What's the?
No, you didn't skip it,
Okay, go on.
but then it will be the other people too.
Well,
Just this last.
I want to apologize if I didn't get to your question. As you know, we are not skipping any question. We are addressing them in the order we received them. And you have to understand, imagine if you are the one in detention too and you need my attention, it will be unfair if I don't attend to it. And besides, I'm the one that filed the motion for bond, so it's something I have to deal with, unfortunately. What I can do is that if there is a way we can see all these unanswered questions for this week so that by next week we answer them first before we go into any other thing. But for now, I have to leave. I have to apologize if I'm not able to answer your question. Just remember to follow us on all of our social media platform. Until next week, I hope to see you again. God bless you.